Title 4, Concealment. Section 26. A neglect to communicate that which a party knows and ought to communicate is called a concealment. Section 27. A concealment, whether intentional or unintentional, entitles the injured party to rescind a contract of insurance. Section 28. Each party to a contract of insurance must communicate to the other in good faith all facts within his knowledge which are material to the contract and as to which he makes no warranty and in which the other has no means of ascertaining. Section 29. An intentional and fraudulent omission on the part of one insured to communicate information of matters proving or tending to prove the falsity of a warranty entitles the insurer to rescind. Section 30. Neither party to a contract of insurance is bound to communicate information of the matters following except in answer to the inquiries of the other. A. Those which the other knows. B. Those which in the exercise of ordinary care the other ought to know, and of which the former has no reason to suppose him ignorant. C. Those of which the other waives communication. D. Those which prove or tend to prove the existence of a risk excluded by a warranty and which are not otherwise material. And E. Those which relate to a risk exempted from the policy and which are not otherwise material. Section 31. Materiality is to be determined not by the event, but solely by the probable and reasonable influence of the facts upon the party to whom the communication is due, informing his estimate of the disadvantages of the proposed contract or in making his inquiries. Section 32. Each party to a contract of insurance is bound to know all the general causes which are open to his inquiry, equally with that of the other, and which may affect the political or material perils contemplated, and all general usages of trade. Section 33. The right to information of material facts may be waived, either by the terms of insurance or by neglect to make inquiry as to such facts, where they are distinctly implied in other facts of which information is communicated. Section 34. Information of the nature or amount of the interest of one insured need not be communicated unless in answer to an inquiry except as prescribed by Section 51. Section 35. Neither party to a contract of insurance is bound to communicate, even upon inquiry, information of his own judgment upon the matters in question. Title 5. Representation. Section 36. A representation may be oral or written. Section 37. A representation may be made at the time of or before issuance of the policy. Section 38. The language of a representation is to be interpreted by the same rules as the language of contracts in general. Section 39. A representation as to the future is to be deemed a promise unless it appears that it was merely a statement of belief or expectation. Section 40. A representation cannot qualify an express provision in a contract of insurance, but it may qualify an implied warranty. Section 41. A representation may be altered or withdrawn before the insurance is effected, but not afterwards. Section 42. A representation must be presumed to refer to the date on which the contract goes into effect. Section 43. When a person insured has no personal knowledge of a fact, he may nevertheless repeat information which he has upon the subject and which he believes to be true, with explanation that he does so on the information of others, or he may submit the information in its whole extent to the insurer, and in neither case is he responsible for its truth, unless it proceeds from an agent of the insured whose duty is to give the information. Section 44. A representation is to be deemed false when the facts fail to correspond with its assertions or stipulations. Section 45. If a representation is false in a material point, whether affirmative or promissory, the injured party is entitled to rescind the contract from the time when the representation becomes false. Section 46. The materiality of a representation is determined by the same rules as the materiality of a concealment. Section 47. The provisions of this chapter apply as well to a modification of a contract of insurance as to its original formation. Section 48. Whenever a right to rescind a contract of insurance is given to the insurer by any provision of this chapter, such right must be exercised previous to the commencement of an action on the contract. After a policy of life insurance made payable on the death of the insured shall have been enforced during the lifetime of the insured for a period of 2 years from the date of its issue or of its last reinstatement, the insurer cannot prove that the policy is void ab initio or is rescindable by reason of the fraudulent concealment or misrepresentation of the insured or his agent. Title 6. The Policy. Section 49. The written instrument in which a contract of insurance is set forth is called a policy of insurance. Section 50. The policy shall be in printed form which may contain blank spaces, and any word, phrase, clause, mark, sign, symbol, signature, number, or word necessary to complete the contract of insurance shall be written on the blank spaces provided therein. Any rider, clause, warranty, or endorsement purporting to be part of the contract of insurance and which is pasted or attached to said policy is not binding on the insured unless the descriptive title or name of the rider, clause, warranty, or endorsement is also mentioned and written on the blank spaces provided in the policy. Unless applied for by the insured or owner, any rider, clause, warranty, or endorsement issued after the original policy shall be countersigned by the insured or owner, which countersignature shall be taken as his agreement to the contents of such rider, clause, warranty, or endorsement. Notwithstanding the foregoing, the policy may be in electronic form subject to the pertinent provisions of Republic Act No. 8792, otherwise known as the Electronic Commerce Act, and to such rules and regulations as may be prescribed by the Commissioner. Section 51. A policy of insurance must specify a. the parties between whom the contract is made, b. the amount to be insured except in the cases of open or running policies, c. the premium, or if the insurance is of a character where the exact premium is only determinable upon the termination of the contract, a statement of the basis and rates upon which the final premium is to be determined, d. the property or life insured, e. the interest of the insured in property insured if he is not the absolute owner thereof, f. the risks insured against, and g. the period during which the insurance is to continue. Section 52. Cover notes may be issued to bind insurance temporarily pending the issuance of the policy. Within 60 days after its issue of a cover note, a policy shall be issued in lieu thereof, including within its terms the identical insurance bound under the cover note and the premium therefore. Cover notes may be extended or renewed beyond such 60 days with the written approval of the Commissioner if he determines that such extension is not contrary to and is not for the purpose of violating any provisions of this code. The Commissioner may promulgate rules and regulations governing such extensions for the purpose of preventing such violations and may by such rules and regulations dispense with the requirement of written approval by him in the case of extension in compliance with such rules and regulations. Section 53. The insurance proceeds shall be applied exclusively to the proper interest of the person in whose name or for whose benefit it is made unless otherwise specified in the policy. Section 54. When an insurance contract is executed with an agent or trustee as the insured, the fact that his principal or beneficiary is the real party in interest may be indicated by describing the insured as agent or trustee or by other general words in the policy. Section 55. To render an insurance effected by one partner or part owner applicable to the interest of his co-partners or other part owners, it is necessary that the terms of the policy should be such as are applicable to the joint or common interest. Section 56. When the description of the insured in a policy is so general that it may comprehend any person or any class of persons, only he who can show that it was intended to include him can claim the benefit of the policy. Section 57, a policy may be so framed that it will inure to the benefit of whomsoever, during the continuance of the risk, may become the owner of the interest insured. Section 58, the mere transfer of a thing insured does not transfer the policy, but suspends it until the same person becomes the owner of both the policy and the thing insured. Section 59, a policy is either open, valued, or running. Section 60, an open policy is one in which the value of the thing insured is not agreed upon, and the amount of the insurance merely represents the insurer's maximum liability. The value of such thing insured shall be ascertained at the time of the loss. Section 61, a valued policy is one which expresses on its face an agreement that the thing insured shall be valued at a specific sum. Section 62, a running policy is one which contemplates successive insurances and which provides that the object of the policy may be from time to time defined, especially as to the subjects of insurance, by additional statements or endorsements. Section 63, a condition, stipulation, or agreement in any policy of insurance limiting the time for commencing an action thereunder to a period of less than 1 year from the time when the cause of action accrues is void. Section 64, no policy of insurance other than life shall be cancelled by the insurer except upon prior notice thereof to the insured, and no notice of cancellation shall be effective unless it is based on the occurrence after the effective date of the policy of one or more of the following: A. Non-payment of premium. B. Conviction of a crime arising out of acts increasing the hazard insured against. C. Discovery of fraud or material misrepresentation. D. Discovery of willful or reckless acts or omissions increasing the hazard insured against. E. Physical changes in the property insured which result in the property becoming uninsurable. F. Discovery of other insurance coverage that makes the total insurance in excess of the value of the property insured. Or G. A determination by the commissioner that the continuation of the policy would violate or would place the insurer in violation of this code. Section 65. All notices of cancellation mentioned in the preceding section shall be in writing, mailed, or delivered to the name insured at the address shown in the policy or to his broker, provided the broker is authorized in writing by the policy owner to receive the notice of cancellation on his behalf, and shall state: A. Which of the grounds set forth in Section 64 is relied upon, and B. That upon written request of the name insured, the insurer will furnish the facts on which the cancellation is based. Section 66. In case of insurance other than life, unless the insurer at least 45 days in advance of the end of the policy period mails or delivers to the named insured at the address shown in the policy notice of its intention not to renew the policy or to condition its renewal upon reduction of its limits or elimination of coverages, the named insured shall be entitled to renew the policy upon payment of the premium due on the effective date of the renewal. Any policy written for a term of less than 1 year shall be considered as if written for a term of 1 year. Any policy written for a term longer than 1 year of any policy with no fixed expiration date shall be considered as if written for successive policy periods or terms of 1 year. Title 7. Warranties. Section 67. A warranty is either expressed or implied. Section 68. A warranty may relate to the past, the present, the future, or to any or all of these. Section 69. No particular form of words is necessary to create a warranty. Section 70. Without prejudice to Section 51, every express warranty made at or before the execution of a policy must be contained in a policy itself or in another instrument signed by the insured and referred to in the policy as making a part of it. Section 71. A statement in a policy of a matter relating to the person or thing insured or to the risk as fact is an express warranty thereof. Section 72. A statement in a policy which imparts that it is intended to do or not to do a thing which materially affects the risk is a warranty that such act or omission shall take place. Section 73. When before the time arrives for the performance of a warranty relating to the future, a loss insured against happens, or performance becomes unlawful at the place of the contract, or impossible, The omission to fulfill the warranty does not avoid the policy. Section 74. The violation of a material warranty or other material provision of a policy on the part of either party thereto entitles the other to rescind. Section 75. A policy may declare that a violation of specified provisions thereof shall avoid it. Otherwise, the breach of an immaterial provision does not avoid the policy. Section 76. A breach of warranty without fraud merely exonerates an insurer from the time that it occurs, or where it is broken in its inception, prevents the policy from attaching to the risk. Title 8. Premium. Section 77. An insurer is entitled to payment of the premium as soon as the thing insured is exposed to the peril insured against. Notwithstanding any agreement to the contrary, no policy or contract of insurance issued by an insurance company is valid and binding unless and until the premium thereof has been paid, except in the case of a life or an industrial life policy, whenever the grace period provision applies, or whenever under the broker and agency agreements with duly licensed intermediaries, a 90-day credit extension is given. No credit extension to a duly licensed intermediary should exceed 90 days from the date of issuance of the policy. Section 78. Employees of the Republic of the Philippines, including its political subdivisions and instrumentalities and government-owned or controlled corporations, may pay their insurance premiums and loan obligations through salary deduction, provided that the treasurer, cashier, paymaster, or official of the entity employing the government employee is authorized, notwithstanding the provisions of any existing law, rules, and regulations to the contrary, to make deductions from the salary, wage, or income of the latter, pursuant to the agreement between the insurer and the government employee, and to remit such deductions to the insurer concerned, and collect such reasonable fee for its services. Section 79. An acknowledgement in a policy or contract of insurance or the receipt of premium is conclusive evidence of its payment so far as to make the policy binding, notwithstanding any stipulation therein that it shall not be binding until the premium is actually paid. Section 80. A person insured is entitled to a return of premium as follows. A. To the whole premium if no part of his interest in the thing insured be exposed to any of the perils insured against. B. Where the insurance is made for a definite period of time and the insured surrenders his policy to such portion of the premium as corresponds with the unexpired time at a pro rata rate, unless a short period rate has been agreed upon and appears on the face of the policy, after deducting from the whole premium any claim for loss or damage under the policy which has previously accrued, provided that no holder of a life insurance policy may avail himself of the privileges of this paragraph without sufficient cause as otherwise provided by law. Section 81. If a peril insured against has existed and the insurer has been liable for any period, however short, the insured is not entitled to return of premium so far as that particular risk is concerned. Section 82. A person insured is entitled to a return of the premium when the contract is voidable and subsequently annulled under the provisions of the Civil Code, or on account of the fraud or misrepresentation of the insurer or of his agent, or on account of facts or the existence of which the insured was ignorant of without his fault, or when by any default of the insured other than actual fraud, the insurer never incurred any liability under the policy. A person insured is not entitled to a return of premium if the policy is annulled, rescinded, or if a claim is denied by reason of fraud. Section 83. In case of an overinsurance by several insurers other than life, the insured is entitled to a rateable return of the premium proportion to the amount by which the aggregate sum insured in all the policies exceeds the insurable value of the thing at risk. Section 84. An insurer may contract and accept payments in addition to regular premium for the purpose of paying future premiums on the policy or to increase the benefits thereof.